I apologize before I start. The defendant has not showed up to the hearing just yet. I believe that they said they would be self-representing, but they have not showed up, and I am not sure if they would.
My Lord, it says, my understanding is that DLA stated in an email that the defendants would neither be represented nor attending today, and they said that no discourtesy to the court was intended.
You're very faint. Can you increase your volume in some way?
Yes, it may be that I'm not close enough to the microphone. Is that better?
Yes, that's better. Yeah, thank you.
So I don't know if anyone heard that. I'm grateful.
Yep. Very well, Shada, we'll proceed in their absence. I've seen the letter, the email rather, which you forwarded to me yesterday evening, which confirms that they don't intend to appear.
Yes, Your Honor. Thank you. This hearing is in the matter of case number CFI 054-2018 before Justice Lord Angus Glennie. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dentons & Co. Lead counsel is Mr. James Wheel. The defendant is not appearing today.
Yes, thank you very much. Mr. Wheel, you can take it. I've read the skeleton argument, the documents referred to in it, and obviously familiar with the background to the case. I've also seen the recent correspondence, and I wondered whether in light of that correspondence, your motion was to be modified in some way.
Sorry, my motion was to modify.
Well, to be modified in some way. So I still can hardly hear you. Can you turn something up?
Yes, is that better?
Not really.
I'm sorry. Let me see if I can speak through the computer screen.
On the laptop machine itself, there should be a volume thing.
Is that better?
You're now echoing.
Mr. Wheel, can you get closer to the microphone?
Yes, I'm now speaking through a computer microphone, but there's a bit of feedback.
Yes, there's feedback.
Does that work?
That seems to be better, yeah.
Okay, that's fine.
Okay,
I can
that's
hear you
fine.
to speaker. I'm grateful. So, my Lord, what I was proposing to do was to take you first of all to the recent correspondence and just see the developments over the last few days. Our position, broadly speaking, is that the letters from DLA don't give sufficient comfort. An order is required. In my submission, there is no reason why, if the defendants are genuine when they tell us that they're not proposing to pursue substantive relief against SBM, they should have refused to give the undertakings that we'd offered.
Sorry, stop. Have they refused to give them? I've only seen your letter requesting it. I haven't seen any refusal.
Yes, it's the easiest thing to do, just to go briefly through the correspondence from the defendants.
The recent correspondence, yeah.
Yeah, I think in order, it's probably worth starting with the letter of the 30th of December, which was in response to the request that we made that they withdraw the proceedings. And you'll find that at tab 25 of bundle AA. As it's an email chain, you need to start from the bottom, which is at page 617.
Yeah.
So Dentons there refer to the disputes. They refer in the middle of that email to clause 27, and they ask for confirmation by Wednesday the 29th that they'll withdraw their application. If you scroll up, the response that comes back from the defendant's Sharjah lawyers was not to acknowledge that there was any problem at all, but you see about 5 paragraphs down, they say that the addition of SBM Bank is warranted in order to address the confined scope of transfer of funds. They then dispute that the exclusive jurisdiction clause is effective because they refer to clauses 15.6 and Schedule 5. And in light of that, they then go on to say that it is the bank that is being contemptuous towards the Sharjah courts, and effectively they rebuff the request that was made. Now, that was the end of the correspondence until DLA corresponded with us only yesterday. The first letter in the relevant chain is at tab 30. And it's worth just looking at that letter.
Yep.
So just to highlight paragraph 4, the DLA accept that the sums, of course, were advanced under the terms of the facility agreement. So there is no dispute, it now seems, that the facility agreement is the source of the relationship between SBM and the defendants. And although they don't say so expressly, DLA don't dispute that the consequence of that is that the exclusive jurisdiction clause bites. What they then go on to say at tab 6, paragraph 6, is that the first effect has been required to prove that payments were made. They say that they're unable to do that without expert evidence. And if you turn over to page 2, about 4 lines down, DLA asserts that the first defendant has sought to join NBK and the claimant purely for the purpose of enabling a court-appointed expert to carry out his mission. But as I'll show you in a moment, that isn't in fact correct when you look at what the documents filed in Sharjah say. Just pausing there, make 2 points. First of all, there is currently an extant application before the Sharjah court to join SBM and to seek substantive liability against it for over 30 million. And so far as we're concerned, that application is live, and nothing we have seen has satisfied us that that application does not yet fall to be determined. The second point we make is that no proper explanation has been given as to what further documents might be required. As the court commented in its judgment, there was a voluminous trial bundle in this case, which consisted in large part of documents disclosed by SBM in relation to all of the transactions as between it and Prime and RENISH. And contrary to what is set out in DLA's recent letter, I'm instructed that we have disclosed all documents in our possession in relation to the 1st to 6th payments inclusive, notwithstanding that it is only the 3rd to 6th payments that form the subject matter of the claim. Because you'll recall those earlier payments were brought into issue by Prime and thereby triggered disclosure obligations on our part.
Surely, for present purposes, I'm not concerned with whether if the application in the Sharjah court is limited to seeking discovery from you of documents which they may or may not have already been disclosed. It's not for me to second guess the Sharjah court on that aspect.
Well, there are two elements to this. First of all, as you've seen, we say that the proceedings were in breach of the jurisdiction clause. There's a second limb, which is that they're vexatious and oppressive. Now, for the purposes of
hang on a second. If they're simply seeking third-party discovery, let's use that term for short. If they're simply seeking third-party discovery, it's not for this court to judge whether there is further documentation which your clients ought to give or not.
Well, in my submission, this isn't the key plank to my case, but it is relevant, because if your lordship considers that the third-party disclosure application is baseless and speculative, that feeds into whether or not the foreign proceedings are vexatious and oppressive. And if all you're told by DLA, as you will be told, is that they are instructed that their client subjectively believes that we have further documents, and there is actually no evidence that they've put before the court to suggest that there are further documents, then in my submission, the only inference to be drawn is that the third-party disclosure application, leaving aside the substantive proceedings, is vexatious and oppressive.
So are you suggesting that, I understand the case based upon the jurisdiction clause, so leave that aside for the moment. I also understand a case based on vexation if the proceedings in the Sharjah court might be designed or objectively might act so as to undermine what has already taken place in the DIFC. I understand those points, but assuming that for the moment that they simply seek third-party discovery against you as a third party,
yes.
Then that on the face of it doesn't fall into either of those categories. And if it's said, can it really be the case that a court of the DIFC could injunct proceedings in another jurisdiction simply because the DIFC court was persuaded that those proceedings in the other jurisdiction were without merit?
My lord, I accept that if it is purely limited to third-party disclosure, and there is no question of any substantive relief being sought either now or in future, I agree with what your lordship has said. The difficulty we face at the moment is we are not entirely clear, or not at all clear, as to what animal we're grappling with in the Sharjah court. It seems to be some sort of hybrid joinder application, a claim for substantive relief, and with elements of disclosure attached to it. And
okay.
when taken, and that all your lordship can consider is the documents that have been filed in Sharjah, and when taken in the round, in my submission, the only fair conclusion that can be drawn at this stage is that there are substantive components to it. Now, when we come, if your lordship is with me, to the form of the order, it may be that we could carve out some exemption so that it enables them to apply for third-party disclosure on terms that it doesn't constitute or contain any substantive relief.
Yeah. What is suggested in paragraph 9 of the DLA letter yesterday, I think it was, seemed to me they do it by way of explanation or confirmation, and in light of the proposed amendment in the Sharjah court. Something along those lines would satisfy you, wouldn't it?
Well, no, in that. Sorry, when you say would something along those lines, embodied in a court order.
An order reflecting that the position taken by DLA in paragraph 9 would give you the
yes, it would. If there was a mandatory injunction requiring them to delete, as they put it, or we would say withdraw any substantive claims, and there was a prohibitory injunction stopping them from pursuing any substantive claims in future, that would satisfy us, and that is the order we seek.
And is that something that I haven't seen the proposed consent order which you sent to them?
Yes, that should be uploaded. So let me give you the reference. It's obviously a consent.
So where's that?
I think it's tab 37, and it's obviously not going to be a consent order anymore.
I don't have a tab 37. I've got a tab 35, draft consent order.
Well, I think it appears in two places. Try tab 34. Yeah.
Right.
Paragraph 2 doesn't make sense. It's not an undertaking. It's the defendant shall. That should be.
Yeah. That goes rather further than that. That seems to stop them bringing any third-party disclosure proceedings, joining you to any third-party disclosure proceedings in Sharjah. sorry, bad express. That seems to stop them joining you to the action simply, even if only simply for the purpose of third-party disclosure.
Yes, it does. And if your lordship were to require that to be carved out, then the order would need to be amended. Yeah.
Is there any? I mean, take me through the rest of the correspondence if you want to. But is there any difficulty with an order which simply prevented them from joining you, from pursuing substantive claims against you in the Sharjah courts, but allowing them to take such steps as may be appropriate for any other purposes, any other non-substantive purposes? It could be tidied up in wording, but
yes, subject to tightening up in wording. I'll take instructions, but I think that meets the principal concerns that we have.
Yeah. And has there been any response to this draft consent order?
Yes, there was a response. I received it overnight on the 6th of January. I don't know if your lordship has refreshed case lines recently.
I just loaded it about 20 minutes ago.
It should have been up then. To try tab 35.
I've got tab 35. That's my last tab.
Yes.
Right. I'll just read. Just give me a second to read this. Yes, I see. Right, well, that seeks to give an explanation of the other documents that they want. And I can't remember whether there was full disclosure of documentation relating to the first three transactions.
My instructions that there are, but I'm not sure for present purposes that it matters.
We can't resolve that. And they're now willing to remove the claim for costs.
Yes, so we would want the definition of substantive claims to extend to any applications for orders for costs.
Okay. So the difficulty here is first the existence of the present proposed claim as yet unamended. Secondly, the proposed amendment is satisfactory except with the additional amendment of deleting the claim for costs. And thirdly, it ought to be in the form of a court order, you say, or an undertaking to the court.
Exactly. These are defendants that your lordship has found liable in fraud, and we simply can't take at face value what's stated on instructions in correspondence.
And I suppose particularly so since DLA Piper are not the lawyers acting in the Sharjah proceedings.
Exactly, and therefore they're outside of their control.
All right.
And in relation to costs, it's well established, at least under English jurisprudence, that where a defendant issues proceedings in breach of an exclusive jurisdiction clause, the default position is indemnity costs. There is a judgment or an order rather of Justice Sir Jeremy Cook in the DIFC in the Hyrie case, which is at tab 2 of the authorities bundle, where his lordship made the same order in the DIFC. Now, the defendants in this case say that it was all an unfortunate error. Well, that's as maybe, but we can only deal with the documents that are filed in the Sharjah courts, and those documents sought substantive relief in flagrant violation of the jurisdiction clause.
Yeah.
We haven't produced a schedule, so the order we invite your lordship to make is simply that costs be assessed on the indemnity basis if not agreed.
Yes. Now, what I would like from you maybe is, I think you accept that the consent order which was intimated to DLA Piper is not terribly brilliant. No doubt it was done under duress of time and so on. But is it possible for you to have a go at amending that consent order? I've now lost it. Where do I find the consent order?
Absolutely. Tab 34. And could I just say this, that rather than expressly permitting them to bring disclosure applications or whatever other sort of interlocutory applications they wish to, the order is simply restrictive. So it stops them from pursuing substantive relief, and we can define substantive relief in a way that your lordship's happy with. And then it's a matter for them, if they think that there are other matters that they can pursue outside of the order, to do so.
Yes, I think you could put in the recital. The first upon is fine. The second one would have to come out as having agreed to the terms of this consent order.
Yes.
But it would be upon the defendant by its solicitors and name DLA Piper there.
Yes.
Having and what I'm trying to find is some wording to reflect the fact that they've intimated that they
have no intention of
sorry,
no intention of commencing these substantive claims, and that the sole.
Well, no, just before that, they've intimated that they have amended the application in terms of similar to 9.1 of their letter.
Yes.
So to delete any substantive claim, and also by their subsequent letter, their letter of 6th of January, that they proposed to amend to delete the claim for costs.
Yes.
And 3, that they do not intend to pursue, etc. And this is 9.2 of their letter.
Yes.
And then it is ordered and leave out by consent. That the defendants, and then 2, undertake to.
Well, if it's being ordered, it should be defendant shall.
Yeah, sorry, yes, defendants shall. And A would be amend their application
So as to withdraw any claim for substantive relief.
Yes, basically 9.1.
Yeah.
And to remove any claim for costs. And then B is not pursue
perhaps of if A deals with the proceedings that are already on foot. Well, no, I mean, it may not be, I don't know anything about Sharjah procedure, but it may not be within the gift of a party to withdraw an application. And therefore, if the application is before the court, we do need a further order requiring them not to pursue it. But we could qualify B by saying at the end, insofar as it relates to any claim for substantive relief or costs.
Yep. Yes, insofar as it relates to any, what was your wording?
Insofar as it relates to any substantive relief or costs against the claimant.
Yep, yep.
And C should be unobjectionable because that's talking about new proceedings, which we're told there's no intention of instituting.
Again, C should be limited to substantive proceedings, seeking substantive relief.
Okay.
In a similar wording to B, to
Yes.
what's going into B. Right. Would it be useful, and there's two ways of proceeding. I'm willing in principle to grant the order, both because of the jurisdiction clause in the finance agreement and the facility agreement and the is the guarantee relevant here?
It's not, because the claim in Sharjah doesn't engage the guarantee.
Okay, under the facility agreement. And secondly, I would accept the proposition that if there were a substantive claim in the Sharjah proceedings, it would be vexatious. If you don't want to argue that I should go further than that and further than the order I suggest, then I'd be willing in principle to make that order. But I wonder whether life would be easier for you, quite apart from the court's point of view, if you put that proposed order before DLA Piper to see whether, with that wording, as opposed to your previous wording, they would be willing to consent to it, in which case you might be in stronger ground when you get to Sharjah.
Yes, yes.
Imagine it's a matter of half an hour as to whether they will or won't.
Yes. Can I take? I haven't had a chance to take instructions on a number of points your lordship's raised.
Yep.
In relation to and including on whether we need to go further. I wonder if I could take 10 minutes.
Have longer if you like. We're down for 2 hours, so if you want to take 20 minutes.
I'm grateful. Well, perhaps we'll let the court know when we're ready, and then we're in your lordship's hands.
Well, it's better if we have a check-in time. So we'll have a check-in time, say in quarter of an hour, and you can say if you want longer.
I'm grateful.
But before you go away, presumably you would want a written reason judgment before the Sharjah hearing on the 10th.
That would be very helpful, my lord. I don't want to add to your lordship's burden, but yes.
Presumably it can be quite short, though.
Yes. If your lordship is minded to give a reasoned judgment, there are a couple of further DIFC authorities not referred to in my skeleton. They don't add much, but they are examples of the willingness of the DIFC court to grant anti-suit injunctions. If I could just give you the references and paragraph references, just for your lordship's note.
The main one you rely upon is Justice Sir Jeremy Cook, is that right? In Hyrie?
Yes, although that's a very, very brief order rather than the judgment. The main judgment referred to in the skeleton is the FedEx case and Jamil, but that was a case where the court didn't grant an anti-suit injunction. So but there are
Which one is that? What tab is that?
That's tab 1 of bundle AB.
The one from Judge Shamlan Sawari.
Sawali, yes. So the reason we rely on that is because it was recognised that the court has jurisdiction under Article 34, and also that English jurisprudence is influential. But on the fact
that was a case with third-party discovery.
Exactly.
An issue.
Where that discovery was supportive of the substantive proceedings. But the three cases, if I could just very briefly refer to them. First is the Emirates case. This is Justice Wayne Martin at tab 5. Rather like the present case, this was one that involved a banking facility and a default under a facility. But the relevant reasoning starts at paragraph 77.
Right.
And paragraphs 80.
Basically says it follows the English approach in this. So is that what it says?
Exactly, and acceded to the application.
Yep.
The next one is a Court of Appeal decision last year, which is at tab 4 in Listran and Locan. And the operative parts of the judgment are really paragraphs 19 to 22.
Yeah.
And finally, Ludian and Lucina, tab 3. This is just an order, but it's you can see that it was an order in mandatory terms at paragraph 4, as well as prohibitory. So yeah. I thought it was a decisional order just to see three recent examples from the DIFC where the anti-suit injunction has been granted.
And the main principles you rely upon are those set out in the, I think it's by Lord Mance, particularly in the Supreme Court case in. Which one?
I can't pronounce it, but it's AES Ust, tab 13.
Yep. And Turner and Grovitt and Donahue and
all of which I'm sure the Lordship is very familiar with already.
Yeah. Yes, thank you. Now I've used up some of your talking time, so do you want to have until what 5 to 10 UK time?
Yes, we'll log in back there.
Right. Very well. Just Sharla.
Yes, Your Honor.
You've gone faint now. We're going to adjourn for 20 minutes till 5:02. All right.
Sounds good. I will be here. Thank you, Your Honor.
Thank you very much. Okay. Yes, good morning.
Thank you, my lord. I've taken instructions, and I'm not instructed to go further and seek to preclude the defendants from pursuing a disclosure application, but subject to the following important point, which is this. We are concerned that the defendants may seek to use the fact of the Sharjah proceedings and SBM being a party to it as a means of delaying and obstructing the orders made by the DIFC court, including your lordship's orders. And so what we would ask is to include a further restriction which prohibits the defendants from relying upon the Sharjah proceedings for the purposes of delaying or obstructing the enforcement of any orders made in this court. And on that basis, they've got nothing to worry about if that's not the game they're playing, and if they're genuinely joining SBM for the purposes of obtaining disclosure. But in my submission, the court should be wary of game playing and procedural manoeuvring, and it would be wrong for them to join SBM merely as a procedural manoeuvre to stop SBM enforcing the order that your lordship's made against them most recently in relation to the fraud judgment.
Yes, how would you word that?
So I propose adding that the defendants, this would be new D, shall not rely upon the existence of the Sharjah proceedings for the purpose of obstructing or delaying the enforcement of any orders made in these proceedings.
Yes. Now, I can see no difficulty with that. Yeah, that seems to make sense. What I don't have, though, written down, the wording we discussed for revised version of A, B, and C.
Yes.
Is that something that you could email to the registry? And
yes.
I can hack it around.
Absolutely. So there are two ways in which we can. We either do that. Does your lordship have in mind that we would then send the version as approved or amended by your lordship to DLA? Then?
No, it's probably better if it's done before I make the order. If you can suggest that the court is minded to make an order in these terms, would you be willing to consent to it, or? Well, just if so, it can be a consent order.
Yes, and given that the hearing in Sharjah is on Monday, we should probably give them until 4 p.m. today. And if we haven't heard back, we just invite your lordship to make an order without consent.
Yeah, and I better proceed to put together some reasons which can be issued with the order.
I'm grateful. So I'll put square brackets around by consent, so that and I'll highlight those so that they can be deleted in the event that we don't hear back from DLA. I will work on that straight away.
And you'll change to get rid of undertake.
I will. Yes, I will endeavour to reflect all of the amendments your lordship made. There isn't any harm, I don't think, in us copying the court into the letter from DLA, so you can see what's sent, and if there are any particular issues or concerns, obviously your lordship can raise them and we can address them.
Well, is it worth just tidying up what you proposed by way of A, B, and C?
Yes, well, yeah, I think although it's painstaking, it may be easiest just to go through it. Sorry.
Two would, well, is there anything in one that changes? The recital in the second and upon, I've discussed that with you already.
And upon the defendant's solicitors, and I will just reflect what is set out in 9.1 and 9.2 of their letter. So that will go in a recital.
In addition, there is the cost thing. That they are going to delete the claim for costs.
Yes.
As set out email of whatever date it was.
Yes. Yes, I will do that as well. Then once
what you could do is, I'll tell you what, logistically the best way of doing this. If we talk through it and you can draft it as we talk, you could then email it to the registry, who will copy it immediately to me. I will say if there's any problem, and then the registry can let you know that that's fine, or they want to change or two. So if it can be done by way of email, then it's easier for me to make any adjustments.
Of course.
So the second recital, though, the second upon, would be in those terms, reflecting 9.1 and 9.2, plus also their letter or email saying they'll also delete the claim for costs.
Yes.
Yeah. And then by consent will be in brackets after that. Order by consent. And then actually the brackets go around the whole of the bit after it is ordered. It goes around, it is ordered that, and then the rest is in brackets. And then 1 is all right, I think, A and B. Isn't that no change you need to that, is there?
No. Oh, I'm sorry, one important point. There needs to be a penal notice in this order, otherwise there will be no consequences that flow from it if it's breached. So I'll need to add a penal notice.
Penal notice as in the draft order you sent to the court?
Exactly.
Yeah. Right, then 2 would be, how would 2 change? Withdraw and procure the withdrawal of the application.
As a joint litigant, insofar as it seeks substantive relief and/or costs against the claimant.
Yeah.
And we'll use that formulation throughout.
Then not pursue, assist, or kill the application made in the show.
So insofar as
it seeks substantive relief and/or costs against the claimant.
Yes.
And then 3 would be, C would be similar, I think.
Yes, perhaps they rather than it, insofar as they seek substantive relief and/or costs. And then new D.
As we discussed, yeah. Shall not rely upon the existence of the charge of proceedings for the purpose of obstructing or delaying the enforcement of any orders made in these proceedings.
Yes.
So this introduced, when you start with 2, the defendants undertake to, it should simply say the defendants : and then A shall withdraw.
Well, if it's the defendant shall : then
then B is, you're dividing the shall and not, and that's grammatically untidy. I think it's the defendants : shall withdraw, shall not pursue, and D shall not rely.
Yes.
Sorry,
It's okay.
being pernickety.
Okay, I've made those changes.
And then three remains, I think.
Yes. I'll take instructions. I'm not sure it's in our interests to force an assessment if not agreed within 14 days if we want to avoid the costs on that. But could I just...
Well, as far as I'm concerned, it doesn't have to be 14 days just to assess by a registrar if not agreed.
Yes.
That's the usual order, I think.
Yes.
I wouldn't put 14 days in because you may then lose your right to costs.
Yes. I'm grateful. Well, I've made those changes. I'll need to elaborate on the second recital to reflect the letter, but I think I can do that in the next 5 or 10 minutes.
If you can get it to Sharla at the registry, or whoever you normally correspond with at the registry, and ask them to forward it to me as soon as possible. Sharla, is that all right?
Yes, correct, Your Honor.
When you get it, could you check for style so that the proposed draft is in the style of the court, not the style the court normally uses for orders of this sort? But if you send it to me at the same time, I can check through it and then liaise with you by email.
Sounds good, Your Honor. I will do that.
Okay, well, unless there's anything else to do at the moment, I'll adjourn this hearing on the basis that if there's a difficulty with the draft, we can resume it. But I hope the draft will be with me within the next 20 minutes, half an hour.
Latest. Yes, I'm very grateful, my lord.
Yeah, very well. I'll adjourn at this stage. Thank you.